You're listening to The Trial Lawyer's Handbook, a courtroom preparation podcast series brought to you by Holland & Knight. This series is hosted by litigation attorney Dan Small. Listeners of this series will gain a fresh perspective on how attorneys can address various trial preparation issues and set themselves up for success in and out of the courtroom.
We try cases to win. We are competitive by nature, and we'd have it no other way. But every case is different. Sometimes it's hard not to wonder what it is we have really accomplished by winning. How do we define success? The Occupational Safety and Health Administration, OSHA, asked the Department of Justice to prosecute the Farmers Export Grain Elevator explosion case that we've been talking about in prior episodes, because they saw a problem in the grain elevator industry that they had been unable to fix. 54 people had died in 2 explosions in 5 days. Something needed to change. Something had to get the grain industry's attention. Maybe prosecuting these 2 individual managers would help. I was sent down from Washington, D.C. to assist. Everyone understood that this was not an ordinary case. There was much more at stake. Throughout the month-long trial, the jury was very attentive, clearly upset about the deaths, but tough to read on the bigger issues. Some of the evidence was hard to hear. Workers in tears about the deaths of their friends and co-workers, and angry that management hadn't done more to prevent it. The coroner using the manner of death of each victim to show the force and weight and direction of the explosion. Investigators describing the chaos and devastation. And every night I'd go back to my government-rate hotel room and wonder what the jury was thinking. White-collar crime was still a stretch back then. Criminals were ruffians, not managers in suits and ties. After the closing arguments and instructions from the judge, the jury went out to deliberate. It felt like forever, but I think it was 4 days. Finally, it became clear that they could not reach a unanimous verdict. What we heard was that they were unanimous in agreeing that the 2 managers had done wrong, but 3 of them could not make the next step to call them criminals. So the jury was deadlocked, 9-3 for conviction. Judge Gibson had to call a mistrial. There it all was. There it was, all that hard work and a month of trial, and all we got was a hung jury. Winning is the goal of every trial, and by that measure, I had failed. Dejected, I wandered around the courthouse, spent some time in a local bar I'd come to like, packed up my stuff, and headed back to my office in Washington, D.C. It was not an easy time. But then a remarkable thing started to happen. When a jury is deadlocked and the judge declares a mistrial, the government in a criminal case has the option to retry the case. To make that tough decision, 2 main questions are usually at the forefront. 1, what could we do differently or better in a second trial that might lead to a different result? And 2, what would be the purpose of a retrial? What would we accomplish? Sometimes the answers are clear and easy. For example, question 1. Well, witness X screwed up badly. If we retry the case without him, using other witnesses instead, it would be much better. Or question 2. This is a serious, violent criminal. We cannot let him get away with it. We have no choice. The answers in the Farmers Export case were different. On the first question, it was very flattering to me. The consensus was that, despite my complete inexperience, the evidence had largely come in as we wanted it. There were no glaring errors and no major strategy changes that might lead to a different result next time. In short, there was no reason to believe that a retrial would go better, and it might even be tougher, since the defense now knew our case and had a better idea of how to defend it. All this was nice to hear, but it was on the second question that things turned in an extraordinary way. From all kinds of sources, our OSHA investigator Don Donnelly, other OSHA folks, people in the grain industry, from all sources we were told, hung jury or not, our message had been heard. No one saw a month-long criminal trial and a 9-3 vote for conviction as vindication for those two executives. They saw it as a clear shot across the bow to the industry, essentially telling them, clean up your act. While I was bemoaning my loss, others were seeing it very differently. It took me a while to really understand that. In the end, the U.S. Department of Justice, with OSHA's agreement, decided not to retry the case. There was no reason to believe that a second trial would go better, and more importantly, to the extent that part of our purpose was to send a message, to be a force for change. We had won. OSHA told us that grain elevators around the country started to change their practices, to change their attitudes as well, and be a whole lot more responsive when OSHA walked in the door. I don't keep the statistics, so don't sue me if there's an outlier somewhere, but I was told that after 54 workers died in 2 explosions, in 5 days that terrible December, there was not another multiple death explosion in a grain elevator for at least 10 years. 10 years. Win or lose, succeed or fail, in every case we need to think about, what do those words mean to us? What are we looking to accomplish? Sometimes the definitions are easy, but don't be too fast to judge. All I know is that the farmers' export trial, one of my biggest failures in the sense of not winning, will always be one of my proudest victories. Lessons learned.
Thank you for listening to the Trial Lawyer's Handbook, a courtroom preparation podcast series brought to you by Holland & Knight. For more information on courtroom preparation, please email dan.small@hklaw.com or visit hklaw.com/Daniel-Small.